Chapter 9 Penal and Disciplinary Sanctions Art. 117. Subject to the provisions of the present chapter, the laws in force in the territory in which they are detained will continue to apply to internees who commit offenses during internment. If general laws, regulations, or orders declare acts committed by internees to be punishable, whereas the same acts are not punishable when committed by persons who are not internees, such acts shall entail disciplinary punishments only. No internee may be punished more than once for the same act or on the same count. Art. 118. The courts or authorities shall in passing sentence take as far as possible into account the fact that the defendant is not a national of the detaining power. They shall be free to reduce the penalty prescribed for the offense with which the internee is charged and shall not be obliged, to this end, to apply the minimum sentence prescribed. Imprisonment in premises without daylight, and, in general, all forms of cruelty without exception are forbidden. Internees who have served disciplinary or judicial sentences shall not be treated differently from other internees. The duration of preventive detention undergone by an internee shall be deducted from any disciplinary or judicial penalty involving confinement to which he may be sentenced. Internee committees shall be informed of all judicial proceedings instituted against internees whom they represent, and of their result. Art. 119. The disciplinary punishments applicable to internees shall be the following. A fine which shall not exceed 50% of the wages which the internee would otherwise receive under the provisions of Article 95 during a period of not more than 30 days. Discontinuance of privileges granted over and above the treatment provided for by the present convention. Fatigue duties, not exceeding 2 hours daily, in connection with the maintenance of the place of internment. Confinement. In no case shall disciplinary penalties be inhuman, brutal, or dangerous for the health of internees. Account shall be taken of the internee's age, sex, and state of health. The duration of any single punishment shall in no case exceed a maximum of 30 consecutive days, even if the internee is answerable for several breaches of discipline when his case is dealt with, whether such breaches are connected or not. Art. 120. Internees who are recaptured after having escaped or when attempting to escape shall be liable only to disciplinary punishment in respect of this act, even if it is a repeated offense. Article 118, Paragraph 3, notwithstanding, internees punished as a result of escape or attempt to escape may be subjected to special surveillance, on condition that such surveillance does not affect the state of their health, that it is exercised in a place of internment, and that it does not entail the abolition of any of the safeguards granted by the present convention. Internees who aid and abet an escape, or attempt to escape, shall be liable on this count to disciplinary punishment only. Art. 121. Escape, or attempt to escape, even if it is a repeated offense, shall not be deemed an aggravating circumstance in cases where an internee is prosecuted for offenses committed during his escape. The parties to the conflict shall ensure that the competent authorities exercise leniency in deciding whether punishment inflicted for an offense shall be of a disciplinary or judicial nature, especially in respect of acts committed in connection with an escape, whether successful or not. Art. 122. Acts which constitute offenses against discipline shall be investigated immediately. This rule shall be applied, in particular, in cases of escape or attempt to escape. Recaptured internees shall be handed over to the competent authorities as soon as possible. In case of offenses against discipline, confinement awaiting trial shall be reduced to an absolute minimum for all internees, and shall not exceed 14 days. Its duration shall in any case be deducted from any sentence of confinement. The provisions of Articles 124 and 125 shall apply to internees who are in confinement awaiting trial for offences against discipline. Art. 123. Without prejudice to the competence of courts and higher authorities, disciplinary punishment may be ordered only by the commandant of the place of internment, or by a responsible officer or official who replaces him, or to whom he has delegated his disciplinary powers. Before any disciplinary punishment is awarded, the accused internee shall be given precise information regarding the offenses of which she is accused, and given an opportunity of explaining his conduct and of defending himself. He shall be permitted, in particular, to call witnesses and to have recourse, if necessary, to the services of a qualified interpreter. The decision shall be announced in the presence of the accused and of a member of the internee committee. The period elapsing between the time of award of a disciplinary punishment and its execution shall not exceed 1 month. When an internee is awarded a further disciplinary punishment, a period of at least 3 days shall elapse between the execution of any two of the punishments, if the duration of one of these is 10 days or more. A record of disciplinary punishments shall be maintained by the commandant of the place of internment and shall be open to inspection by representatives of the protecting power. Art. 124. Internees shall not in any case be transferred to penitentiary establishments, prisons, penitentiaries, convict prisons, etc., to undergo disciplinary punishment therein. The premises in which disciplinary punishments are undergone shall conform to sanitary requirements. They shall in particular be provided with adequate bedding. Internees undergoing punishment shall be enabled to keep themselves in a state of cleanliness. Women internees undergoing disciplinary punishment shall be confined in separate quarters from male internees and shall be under the immediate supervision of women. Art. 125. Internees awarded disciplinary punishment shall be allowed to exercise and to stay in the open air at least 2 hours daily. They shall be allowed, if they so request, to be present at the daily medical inspections. They shall receive the attention which their state of health requires and, if necessary, shall be removed to the infirmary of the place of internment or to a hospital. They shall have permission to read and write, likewise to send and receive letters. Parcels and remittances of money, however, may be withheld from them until the completion of their punishment. Such consignments shall meanwhile be entrusted to the internee committee, who will hand over to the infirmary the perishable goods contained in the parcels. No internee given a disciplinary punishment may be deprived of the benefit of the provisions of Articles 107 and 143 of the present Convention. Art. 126. The provisions of Articles 71 to 76 inclusive shall apply, by analogy, to proceedings against internees who are in the national territory of the detaining power. Chapter 10. Transfers of internees. Art. 127. The transfer of internees shall always be effected humanely. As a general rule, it shall be carried out by rail or other means of transport, and under conditions at least equal to those obtaining for the forces of the detaining power in their changes of station. If, as an exceptional measure, such removals have to be effected on foot, they may not take place unless the internees are in a fit state of health, and may not in any case expose them to excessive fatigue. The detaining power shall supply internees during transfer with drinking water and food sufficient in quantity, quality, and variety to maintain them in good health, and also with the necessary clothing, adequate shelter, and the necessary medical attention. The detaining power shall take all suitable precautions to ensure their safety during transfer, and shall establish before their departure a complete list of all internees transferred. Sick, wounded, or infirm internees and maternity cases shall not be transferred if the journey would be seriously detrimental to them, unless their safety imperatively so demands. If the combat zone draws close to a place of internment, the internees in the said place shall not be transferred unless their removal can be carried out in adequate conditions of safety, or unless they are exposed to greater risks by remaining on the spot than by being transferred. When making decisions regarding the transfer of internees, the detaining power shall take their interests into account and, in particular, shall not do anything to increase the difficulties of repatriating them or returning them to their own homes. Art. 128. In the event of transfer, internees shall be officially advised of their departure and of their new postal address. Such notification shall be given in time for them to pack their luggage and inform their next of kin. They shall be allowed to take with them their personal effects, and the correspondence and parcels which have arrived for them. The weight of such baggage may be limited if the conditions of transfer so require, but in no case to less than 25 kilograms per internee. Mail and parcels addressed to their former place of internment shall be forwarded to them without delay. The commandant of the place of internment shall take, in agreement with the internee committee, any measures needed to ensure the transport of the internee's community property and of the luggage the internees are unable to take with them in consequence of restrictions imposed by virtue of the second paragraph.